Good afternoon, everyone. This is Kristen Justice with BeyondPay, and we are so excited to have you all join our exempt versus non-exempt webinar that we are conducting this afternoon. We see a lot of people are still joining, so we're going to give everybody a few seconds to get acclimated with their monitor with GoToWebinar, and just give a few more seconds for everyone to continue joining our webinar today. All right, so as you're continuing to join, get accustomed to your monitor and to GoToWebinar. You can do this by making sure that it's in the full screen by going in the top right-hand corner, choosing maybe display settings. Every monitor is different, so become comfortable with which view is going to be best for you and your computer that you're coming to us on. So again, thank you so much for joining today's webinar. This is Kristen Justice with BeyondPay, and I am our Regional Sales Manager, and we are just so excited to have you all on. Jason Zahn has many years of experience in HR, so he's going to be able to give you all a full understanding of exempt versus non-exempt employees and the Fair Labor Standard Acts, which, as you all know, is most commonly violated labor law. So he's going to be able to give you all insight into that. So again, thank you for joining. We are so excited to have such an awesome turnout in this afternoon's webinar. We know that your time is valuable and that you all have a very important role in your organizations. And so we thank you for taking this time to learn about a very important topic and to join with us today. So Jason Zahn is our host. He is certified. He has over 20 years of experience in the human resources environment, and he's going to bring a unique perspective on the ever-evolving world of human resources with the latest trends in HR, which today our topic for this webinar is FLSA exempt versus non-exempt employees, okay? So he's going to be talking about the issues involving minimum wage and overtime, how exempt employees are classified, record-keeping requirements, types of coverage, and so much more. So at this point, I'm going to be turning it over to Jason, and just one last thing that I did forget to cover, we are going to have a Q&A session. So what's very exciting about the webinar is you're going to have the ability to ask questions. So go ahead and put questions in the chat bubble on the right-hand side on that gray bar that you're seeing. Put questions in there as we go through the webinar. Go ahead and ask away. And then what we're going to do is at the end of the webinar, we're going to address as many questions as we can. So again, turning it over to Jason, you're in wonderful hands with all of his HR experience, and we hope you enjoyed today's webinar.
Thank you, Kristen. Good afternoon and welcome to the exempt versus non-exempt webinar. We chose this topic as our first webinar for a few different reasons. First, the Department of Labor has recently published a notice to amend the current provision of the FLSA overtime exemption, and this has created a heightened awareness for employers wanting to be ahead of the curve if in fact these changes are adopted. The second reason we chose this topic is because from the numerous HR calls we receive, FLSA compliance is the most widely misunderstood topic, which also has a great deal of financial risk. Misclassified workers cost employers over $250 million in back wages in 2014, and in 2015 is shaping up to be about the same cost. Earlier this month, the Department of Labor released the news that Halliburton, an oil and gas service provider, paid about $18.3 million in overtime that was owed to more than 1,000 of their employees across the U.S. One of the biggest blunders Halliburton ran into was inaccurately categorizing employers as employees as overtime exempt. One thing that is pretty certain is that the Department of Labor will continue its assault on misclassifications. Our goal today is to help prepare you to evaluate where you stand with respect to properly classifying your employees as exempt or non-exempt, and to help you defend your decision in the event of an audit or if a claim is brought against you by a current or former employee. So today we're going to cover basically four topics. We are going to look at the introduction to the Fair Labor Standards Act. We're going to look at exempt employees. Then we're going to look at the definition of non-exempt employees, and then we're going to talk about next steps and talk about a little bit about the new provisions to law. So, an introduction to the FLSA. What is the Fair Labor Standards Act? It is a federal law that sets the minimum standards for child labor, minimum wage, and overtime pay. It also includes a provision for equal pay, which was added under the 1963 Equal Pay Act for men and women performing the same jobs. The child labor, minimum wage, and overtime provisions of the FLSA were passed in 1938, and these provisions were adopted as a means of economic recovery from the Great Depression. The law sought to ensure a maximum number of jobs which paid a minimum livable wage. By requiring overtime, the FLSA created a monetary penalty for employers who did not spread their existing work among a greater number of employees. By setting standards for children to work, it ensured that when young people work, the work is safe and does not jeopardize their health, well-being, or educational opportunities. The FLSA affects more than 100 million workers, both full-time and part-time, in the private and public sectors. To complicate matters, there are many states with laws that exceed the FLSA minimums, such as higher minimum wage or overtime after 8 hours in a day. So you always want to make sure that you are abiding by your state laws. If your state does not have a specific overtime minimum wage or child labor law, then you would simply follow the federal act. One thing to remember is that FLSA sets the minimum standards. Employers are always free to offer more than what is required by law. Oftentimes, collective bargaining agreements or other agreements may exceed the federal state minimum standards. So what are the basic provisions of FLSA? First, with child labor, FLSA restricts the hours that children under 16 can work and forbids the employment of children under age 18 in certain jobs deemed too dangerous. Also prohibits the employment of children under age 16 during school hours and in certain jobs deemed too dangerous. The minimum wage and overtime pay under FLSA, all employees are considered non-exempt. That means not exempt from coverage unless the employee's position meets specific exemption criteria or unless the regulations specifically allow an exemption and the employer has opted to use this exemption. And then the Equal Pay Act under FLSA prohibits gender-based wage discrimination. So some penalties for FLSA violations. First, wage and hour violations. If an employer is investigated for a possible FLSA violation and a violation is found, more than likely investigators may just recommend changes in employment practice to bring about compliance. However, employers who willfully or repeatedly violate the minimum wage or overtime pay requirements are subject to a civil money penalty of up to $1,100 for each violation. And an important note also, it is a violation to terminate or in any other manner discriminate against an employee for filing a complaint or participating in a legal proceeding under FLSA. So penalties for FLSA violations. The Equal Employment Opportunity Commission, or EEOC, administers the enforcement of the Equal Pay Act. Penalties for violations are recovery of compensatory damages for intentional discrimination and punitive damages for discrimination that's intentional and engaged in with malice or reckless indifference to the federally protected rights of the employee. There are, however, caps on the amount of compensatory and punitive damage which are determined by the size of the employer. Some more FLSA violations. Employees ordinarily bear the burden of proof under the FLSA. If the employer has not adequately maintained records, the court may accept the employee's claim and give the employer the burden of disproving allegations. This is why documentation of employee work records is so important. Employers automatically bear the burden of proof for proving any exemption under the Act. We will discuss exemptions in a few minutes. So statute of limitations for FLSA claims, an action for back wages or overtime plus interest should typically go back 2 years from the date the error was found. A 3-year statute of limitations applies in cases where back wages are due to employees because of willful violation. Also, if it is determined to be a willful violation, meaning the employer knew or should have known, the penalty could be $10,000 fine and up to 6 months in prison. Pretty stiff. So some common employer FLSA mistakes. Number one mistake, and probably the most common one that I get, is considering any employee who is paid a salary as an exempt employee who is not eligible for overtime pay without qualifying the employee for a specific job-related FLSA exemption. Probably the number one. Another common mistake is not paying for unauthorized overtime. This would entail when an employer is not paying an employee because the overtime was not approved. Remember that an employee working unauthorized overtime is a disciplinary issue and not necessarily a compensation issue. And then thirdly, making automatic pay deductions for meal breaks without making sure that an employee has actually taken the unpaid break time. Many times, non-exempt employees will work through lunch and then not record the work hours on their timesheet. The employer bears the responsibility of making sure employees take their breaks, and in fact, if they do work during their break, that the employer receives pay for the time worked. So defining exempt and non-exempt employees. An exempt employee is an employee who meets one of the FLSA exemption tests and who are paid on a fixed salary basis and not entitled to overtime. So we're going to look at the FLSA exemption test and also the definition of salary basis. Non-exempt employees are employees who do not meet any of the Fair Labor Standards Act exemption tests and are paid on an hourly basis and also covered by wage and hour laws regarding minimum wage, overtime pay, and hours worked. So what does salary basis mean? To be paid on a salary basis means that the employee receives a predetermined amount constituting all or part of the employee's salary, which amount is not subject to reduction because of variations in the quality or quantity of work performed. In other words, exempt employees must receive their full salary for any week in which they perform any work without regard to the number of days worked or how well the job was performed, with the following exception. Hourly paid computer professionals who make at least $27.63 per hour, doctors, lawyers, teachers, outside sales employees are exceptions to the exempt white-collar employee being paid on a salary basis. So employees in those types of professions are able to be paid on an hourly basis and also be considered exempt. So some specific prohibited deductions from salary. First, partial day absences. Employers may pay for partial day absences using paid leave accounts. An exception to this is when the exempt employee is on FMLA leave, actual pay deductions may be made for partial day FMLA absences. Jury duty and military leave, unless the employee performs no work whatsoever during the employer's standard work week. And then when no work is available, such as during slow periods or when the business is closed due to weather emergency. So if you close your business due to weather, exempt employees must be paid for the entire day. So let's talk about the FLSA exemptions. So there are 6 exemptions for considering an employee as an exempt employee. They are the executive exemption, administrative exemption, professional, which consists of both professional and creative and also learned, the computer-related exemption, outside sales exemption, and highly compensated employee exemption. So those are the 6 exemptions. We'll talk about each one specifically next. So first we have the executive exemption. First of all of these exemptions except for the highly paid one and outside sales requires the $455 per week of pay. So in order to be exempt, you have to at least make $23,660 annually, except for that outside sales position and also the highly compensated exemption, which we'll get to. So to be part of the executive exemption, you customarily and regularly need to direct the work of 2 or more full-time employees or equivalents. The DOL views the terms customarily and regularly as the frequency is greater than occasional, may be less than constant, normally occurs every work week, and does not include one-time tasks. The primary duty for the employee being considered for the executive exemption must consist of managing the company or customarily recognized department of the company. Examples of positions considered to have the executive exemption are executive officer, controller, vice president, or director. So next is the administrative exemption. Again, it must be paid at least $455 weekly or $23,660 annually on a salary basis. The work includes the exercise of discretion and independent judgment with respect to matters of significance. And the DOL views independent judgment as the means the employee is involved in the comparison and evaluation of possible courses of conduct and acting or making decisions after the various possibilities have been considered. Also, it implies that the employee has the authority to make independent choice free from immediate direction or supervision. The DOL views the matters of significance term as the level of importance or consequence of the work being performed. The primary duty for the employee being considered for the administrative exemptions must consist of performing office or non-manual work directly related to the management or general business operations of the company. So what does management mean? So for the DOL, management means interviewing, selecting, and training of employees, setting and adjusting their rates of pay and work hours, directing the work of employees and appraising and disciplining employees, determining the type of material, supplies, machinery, equipment, or tools to be bought, stocked, or sold, controlling the flow and distribution of material or merchandise, and providing the safety and security of employees, planning and controlling the budget, and monitoring or implementing legal compliance measures. And then examples of the administrative exemptions would be manager, supervisor, or administrator. Okay, so next is the professional learned exemption. So again, 455 weekly, 23,660 annually. The employee's advanced knowledge is in the field of science or learning, and the employee's advanced knowledge was acquired by a prolonged course of specialized intellectual instruction with an appropriate academic degree or a combination of degree and experience. The primary duty of the employee being considered for this exemption consists of the performance of work that requires advanced knowledge beyond high school and that is primarily intellectual in character and includes the exercise of discretion and independent judgment. A common mistake, a common mistake that employers make is to automatically make college graduates exempt employees. It is important to consider both the education and the education required and work being performed to be sure they are linked. Examples of positions considered to have the professional learned exemption are accountant, nurse, and engineer. The professional creative exemption is the primary duty of the employees being considered is requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor as opposed to routine, mental, manual, or physical work. Examples of positions considered to have the professional creative exemption are composer, singer, or graphic designer. So the computer-related exemption, the primary duty of the employee being considered for this exemption consists of the application of system analyst techniques and procedures, including consulting with users to determine hardware, software, or system specifications, or the design, development, documentation, analysis, creation, testing, or modification of computer systems or programs, or the design, documentation, testing, creation, or modification of computer programs related to machine operating systems, or a combination of these duties which requires the same level of skills. So examples of the positions considered to have the computer-related exemption are network analyst, developer, and software engineer. And one other thing to mention here, I mentioned earlier about the computer professional being able to be paid on a by-hour basis. So the minimum here on a per-hour basis is $27.63 per hour if they are paid by the hour. So outside sales position, there's not a salary that we need to pay for an outside salesperson. So there's no minimum salary. You can basically make a salary person 100% commission and they can still be exempt. So there's no minimum salary required for the outside sales exemption. So this means the employee in this exemption status are also exempt from the minimum wage provision of the Act. The employee is customarily and regularly engaged in away from the employer's place of business. The primary duty of the employee being considered for this exemption is making sales calls, obtaining orders for contracts, services, or for the use of facilities for which consideration is paid by a client or a customer. Examples of positions considered to have the outside sales exemption are traveling sales persons or contract negotiators. And then our sixth exemption is the highly compensated exemption. So highly compensated employees performing executive, professional, or administrative duties, they must be paid a total compensation of over $100,000, which includes at least $455 per week on a salary basis. So what this means is that as long as they're getting $455 per week, but then maybe bonuses take them over $100,000, then you can have that highly compensated exemption. The employee must customarily and regularly perform at least one of the exempt duties or responsibilities of the executive, administrative, or professional exemption. And the primary duty of the employee being considered consists of performing office or non-manual work. Examples of these positions would be real estate broker or stockbroker. So let's look at the definition of a non-exempt employee. All employees are considered to be non-exempt unless the employer can establish that the employee's position meets one of the 6 specific exemption criteria. Accordingly, the definition of a non-exempt employee is an employee who does not meet any one of the Fair Labor Standards Act's exemption tests and is paid on an hourly basis and covered by wage and hour laws regarding minimum wage, overtime pay, and hours worked. So essentially, what that's saying is that every employee is considered a non-exempt employee unless, of course, the employer can prove one of the 6 FLSA exemptions. So let's look at time worked records. The FLSA requires the following information regarding time worked by non-exempt employees, and this information actually does need to be documented, either in an offer letter or it needs to be published or in a handbook. So the time and day of the week when the work week begins, hours worked each day, the total hours worked each week, basis on which hours are paid, so piecework, hour per hour, etc. Regular hourly pay rate, total daily or weekly straight time earnings, total overtime earnings, additions to or deductions from wages, total wages paid each pay period, and date of payment and pay period covered by payment. So all of these listed here must be documented on a regular basis. That is a requirement of the FLSA. So it's hard to believe, but with all the available technology today, there are still employers manually tracking employee hours. As you all know, manually tracking your employee costs you time and money. In fact, businesses have a 2% error rate when it comes to manual time tracking. So let's say you have a $500,000 payroll per year. With a 2% error rate, you'd find you were wasting $10,000 per year. Using an automated payroll and time and attendance system not only will save you that $10,000 in wasted payroll dollars, but will also help to avoid potential overtime implications like Halliburton saw earlier this month. So time worked records. Employers may use any timekeeping method they choose, time clocks, manual timesheets, electronic timesheets. Under the FLSA, payroll records must be retained for at least 3 years. Records on which wages are based, time cards, timesheets, computer records, must be retained for at least 2 years. Employers may record employees' starting time and stopping time to the nearest 5 minutes, nearest tenth or quarter of an hour, provided that the amounts rounded off average out over time and do not fail to properly compensate the employee. So what this means is that if you always, if you have every nearest 5 minutes and you have an employee who habitually punches in late and you always dock them that 5 minutes, what this is saying is that if the employee punches in early, are you also giving them the benefit of punching in 5 minutes early? So if you're always docking them and never giving them that extra time for punching in early, that could be considered not fairly paying the employee. So overtime pay requirements. For covered non-exempt employees, the Fair Labor Standard Act requires overtime pay at a rate of not less than 1.5 times the employee's regular pay rate after 40 hours in a work week. And remember that there are some states that have different overtime laws, so please be sure to check your state. If you're a client of BeyondPay, you're certainly welcome to call us, and one of our HR professionals will get you that information for your state. Overtime pay is calculated on actual time worked, and you are not required to count paid time off as hours worked for overtime. The FLSA does not require overtime pay for work on Saturdays, Sundays, or holidays. So if an employee works 8 hours per day and is off on a Monday and then works on Saturday, you are not required to pay the employee overtime unless, of course, the hours total over 40 in the work week. So in other words, the FLSA does not require overtime pay for work on nights or weekends simply for working at those times. So compensatory time. A lot of clients call and say, well, I'm going to give my employee compensatory time to take the next week or within the next 30 days and not pay them overtime. And this is a big no-no. So private sector employees must pay non-exempt employees wages equal to 1.5 times the hourly rate for all hours in excess of 40 for a single work week. They cannot provide compensatory time off instead of overtime pay. A few key points here are that the 40 hours must be based on a work week and not a pay period. So if you have an 80-hour pay period, you cannot kind of balance out your hours over the 80 hours. You have to do it per work week. So if you have an employee who works 45 hours in one week and 35 the next week, over the course of the 2 weeks it equals 40 hours, but by the law you have to pay them the 5 hours for the for that 45-hour work week. And overtime must be paid on the company's published work week. You cannot keep changing your work week, so once that's published, you have to continue to pay off that. You can't change the start and stop times of the week. In many companies, overtime must be authorized in advance by an employee's supervisor. If an employee works overtime without authorization, it still must be paid. Remember, unauthorized overtime is a disciplinary issue and not a compensation one. So let's look at compensable time when it comes to travel for non-exempt employees. So home to work travel is not considered work time and is not compensable. Time spent in travel as part of the employee's principal activities, such as travel from one job site to another during the workday, is work time and must be paid. When a non-exempt employee travels on a one-day assignment to another city, the time spent traveling is work time and must be paid. Time spent traveling to an airport terminal or train station is not treated as hours worked. By contrast, all the time spent waiting at the terminal until the arrival at the destination is compensable. So compensable time with meeting and training, time spent attending lectures, meeting, and training programs is counted as hours worked unless all of the following conditions are met. The meetings are held outside of regular hours. Attendance is voluntary. The course, lecture, or meeting is not directly related to the employee's job, and the employee does no productive work during the meeting or training. With trade school or college courses, employees who voluntarily attend courses at independent schools, colleges, or trade schools outside of their regular working hours are not engaged in compensable work time, even if the instructional program is related to their current job. And the key here is that it's voluntary. Also, voluntary attendance by employees outside working hours at an employer-sponsored course that corresponds to courses offered by independent learning institutions does not constitute work hours, even if the courses are job-related. And again, the key word here is voluntary. So rest and meal periods. This question I get quite a bit. The FLSA does not require rest or meal periods. However, when employers offer these short breaks, usually lasting about 5 to 20 minutes, they must be paid time. Bona fide meal periods, typically lasting more than 20 minutes, serve a different purpose than rest breaks and are not work time and not compensable. unless, of course, the employer does not work during this time as previously discussed. So on-call duty, whether on-call or waiting time is to be treated as work time depends on whether the time is spent predominantly for the employer's benefit or for the employees. An employee who is required to remain on call on the employer's premises is working while on call and the time is compensable. An employee who is required to remain on call at home or who is allowed to leave a message where he or she can be reached is not working in most cases and is not compensable. So a few tips on scheduling, managing overtime. So with scheduling, before overtime is worked, an employee should have prior approval from his or her manager. Overtime is considered a condition of employment, and refusal to accept it when reasonable notice has been given is cause for disciplinary action up to and including termination. At the manager's discretion, an employee's work schedule may be adjusted during a work week to avoid overtime. So if you have an employee who maybe worked 12 hours on Monday and you wanted to adjust their schedule for the rest of the work week so that you could avoid the overtime, you are able to do that. And then time worked, approved paid absences including sick leave, vacation leave, holiday leave, FMLA leave, military, jury, and witness duty, voting time off are paid at the employee's regular rate of pay and are not counted as hours worked for the purposes of computing overtime. So let's transition now to next steps and the proposed rule changes for 2016. So on July 6, 2015, the Department of Labor published a notice of proposed rulemaking to amend the Fair Labor Standards Act. The Department of Labor proposed amendments focusing on three key changes to the current FLSA regulations. First, raising the standard salary level to qualify for the white-collar exemption to $921 per week or $47,892 annually. Basically more than double and represents the 40th percentile of the weekly earnings for all U.S. full-time salaried workers. Currently, as we discussed, the amount is $455 per week or $23,660 annually. Second, increasing the total annual compensation requirement to qualify for the highly compensated exemption to $122,148, which is the 90th percentile for all U.S. full-time employees. Currently, the level for highly compensated employees is $100,000, so they're looking to raise that another $22,000. And then lastly, they're looking to establish a mechanism for annually updating the salary and compensation levels for these exemptions going forward. So the Department of Labor has requested comment on the following proposed methodologies to achieve this. So option one is keeping the required levels at a fixed percentile of wages. And option two is basing required salary levels off of changes in inflation as measured by the Consumer Price Index. So the reason that they're looking to do this is because, for years and years and years, the rate has never changed. So they want to have an option in the proposed rule changes to allow for automatic changes to salary levels to be able to justify exempt versus non-exempt. So there's going to be a final rule published in the near future, and the amended regulations would become effective sometime in 2016. And if adopted, the DOL estimates that these changes will impact approximately 4.7 million workers. Once these changes take effect, BeyondPay clients will receive notification of these changes taking effect, and then hopefully prepare you for how you're going to communicate this and make this happen within your organization. So what should employers do to prepare? In anticipation of these changes, employers should evaluate their current employee classifications to determine which employees may become exempt under the revised regulations. So this would be all the exempt employees you currently have right now who are making less than $47,892. These would be the employees who would be affected if they were making less than that. So if they were exempt now and making less than $47,892, if the proposed rule changes go through, they would automatically be considered non-exempt employees, and then you would have to pay them overtime. Also, you need to cautiously determine how to modify your jobs and pay, and then develop a plan for implementing any necessary changes once the revisions take effect. So this wraps up the webinar. To conclude, I would like to mention that in addition to our HRIS technology, BeyondPay is able to provide full HR support for our clients. If you would like more information on the HR services we offer, please do not hesitate to reach out to us. And finally, please stay tuned for information on our next webinar. Thank you very much. I will now turn it over to Kristen to go over a few questions.
Great. Thank you so much, Jason. That was fantastic. And we hope that all of you enjoyed the webinar and gained quite a bit of knowledge in regards to everything that Jason covered today. So thank you so much. And again, we would love to be able to help you all with your HR processes. If you feel like you need additional support, we are here to offer that. And so please don't hesitate to reach out. We would love to be able to support you and help you be more efficient and ensure further compliance in regards to your means of managing your workforce. So we had a lot of really great questions come through. It was fun to be able to see your thoughts as we went about the webinar. A lot of really good questions. And so we're going to try to get to a few of them. Keep in mind, we will not be able to cover all of them because so many of you all interacted, which is fantastic, but we will be following up with each one of you individually. So if we're not able to address your question here during this time with everyone on the line, don't worry, because we will be following up with you individually. So one of the first questions we got is, Jason, can you go over how overtime pay is calculated again? Would you be able to go through that piece again?
Yeah, so the way that you're going to calculate overtime is basically any hours worked over 40, okay? And the key is hours worked. So I gave the example, if somebody was out on Monday and received maybe 8 hours of paid time off, you're only going to be counting the paid or the hours worked. So if they worked 32 hours the rest of the week, okay, you're going to pay them just for 32. If they then came in on Saturday and worked another 8 hours because they were out on Monday, then you would still just pay them 40 hours of regular and then 8 hours of regular PTO time.
Okay, awesome.
So you do not need to pay overtime until the hours worked is over 40. Now also keep in mind that there are some different state laws out there, California being one of them, that it would be anything over 8 hours in one day where an employer would need to pay their employee overtime. So hopefully I answered that question.
Okay, I think you did. Thank you. All right, we have another good question here. Lots of good ones. They're still continuing to come through. Thank you, everyone. Let's see here. Can a company have two different work weeks? So 1 week for hourly employees and 1 week for salary employees?
Yes, they can.
Okay, perfect. All right, you stated that non-exempt are paid on an hourly basis. Isn't it true that non-exempt can also be paid on a salary basis?
That is correct. Yes, they can.
Perfect. This is great. The people that are asking these questions, you're getting instant gratification here. Jason's actually giving the yes answer, and this is perfect. We're all about that. All right, let's see. So this is a unique question. Someone actually wants to know, when you were discussing, Jason, about who goes to prison in willful violation, they actually want to know who goes to prison. How is it determined? The HR manager, the president of the company? Who's
Well,
involved there?
remember that is when it's a willful situation. So it would be the person who should have known about it or did know about it. So if somebody in HR knew about it and chose to do nothing about it and had the authority to do something about it, then yes, it could be HR.
Okay. You guys don't want it to be you, though.
Yes,
You're hoping
definitely
you
don't
give
want
a
it to be
different
you.
answer. Okay, how about if an employee who has to travel to another state for a 4-day training leaves on Sunday? Are those hours paid? The employee is considered non-exempt. So let me just repeat that again. So this is a non-exempt employee who has to travel to another state for a 4-day training, but the employee needs to leave on a Sunday. Are those hours paid?
They are paid, yes. So the employee would be paid from the time that they say they're going to an airport. They would be paid from the time they get to the airport to the time they reach their destination. And then after that, it would be when they start working when they're at their destination.
Okay, Excellent. And we have a lot of people asking about whether or not we're going to share a copy of the slides. Most definitely, we will follow up and
Yes.
provide you with a copy of the slides. All right. So I think at this point, we have a lot of questions still continuing to come through, and we would love to take time to address all of them. But for time's sake, we just want to make sure that we're respectful of everyone's time, because you've already given us 40 minutes of your day, and for that, we are very grateful to have had the opportunity to present to you and hopefully provide you with further insight over today's topic. And so at this point, and Jason, do you have anything further that you'd like to add before we close it up?
No, I just want to say thank you to everybody. Thanks for listening.
Great. Thank you, everyone. And we look forward to following up with each one of you individually. Have an awesome afternoon, and we'll be talking with you soon.